Good afternoon. My name is Kate Schenk, and I'm the Deputy Director of Legal Aid Chicago. Welcome to Legal Aid Chicago's third session of our series, Finding Solutions, Legal Aid for Our Most Vulnerable Populations. Today's session will focus on the issues that seniors face and how legal aid can help. A special thank you to Sidley Austin for their generous sponsorship of this webinar series in general, and for this session in particular. Now to get it started, I'd like to turn it over to Catherine Zahm, who is the Community Programs Manager at Age Options. Catherine?
Great, thank you. And thank you so much for inviting me to be with you today. I'm Catherine Zahm. I'm the Community Programs Manager at Age Options, and I'm really excited to share with you all today some information about our elder justice programs. This includes the Long-Term Care Ombudsman Program and the Adult Protective Services Program. I'll share an overview of our programs, who they help and how they work, as well as how to make a report if you suspect adult mistreatment. Next slide, please. To get us all started, I'll review the different types of abuse that we'll be referencing in relation to our elder justice program. Both the Long-Term Care Ombudsman Program and the Adult Protective Services Program take reports of physical abuse, sexual abuse, emotional abuse, confinement, neglect, deprivation, financial exploitation, and the Adult Protective Services Program does reports of self-neglect. We'll talk later in this presentation about the differences between the Adult Protective Services Program and the Long-Term Care Ombudsman Program, but the quick answer is that if the abuse is taking place in a long-term care facility, that report will go to the Ombudsman. If the abuse is taking place in a home or community-based setting, then that report will go to the Adult Protective Services Program. Later in today's presentation, Michelle and Colleen will go into greater depth on financial exploitation and emotional abuse. But two types of abuse that I would like to highlight include sexual abuse and self-neglect. Next slide, please. It's important to recognize that people of any age can and are sexually abused. We often don't think of this form of abuse affecting older adults or adults with disabilities. So I want to take a moment here to really discuss this topic briefly. Sexual abuse is defined as touching, fondling, sexual threats, sexually inappropriate remarks, or any other sexual activity with an adult when the adult is unable to understand, unwilling to consent, threatened, or physically forced to engage in sexual behavior. Some examples of sexual abuse include the victim being forced to fondle or touch the abuser in a sexual way, forced to engage in or observe sexual activity, or sexual exploitation. Some behavior indicators that may suggest that someone might have experienced sexual abuse include expression of fear around other people, somebody acting more withdrawn or really over-sexualized behavior, and refusing to cooperate with really normal routines. Some physical signs that may suggest that someone experienced sexual abuse include genital or anal bruising and bleeding, swelling or redness of the genital area, and the contraction of a sexually transmitted disease. It's important to note that sexual abuse not only physically damages a person, but it causes emotional and psychological damage as well. It can be perpetrated against an individual who is cognizant. However, in many cases that we're seeing, sexual abuse taking place in nursing homes specifically is often committed against a resident who is incapacitated or unable to knowingly give consent. Next slide, please. I also want to highlight self-neglect because many of us do not typically think of this as something that can be reported. So self-neglect is defined as a condition that is the result of an adult's inability to perform essential self-care tasks that negatively affect their health and well-being. This may include inappropriate dressing, lack of food, shelter, and healthcare. Self-neglect may also display as an inability to obtain goods and services necessary to maintain physical and mental health, emotional well-being, and just general safety. This inability may be due in part to physical or mental impairments, or both. Common elements in self-neglect cases often include adults not seeking medical or mental health care, substance use, compulsive hoarding of possessions or animals, inadequate or no utilities, living in filthy conditions, untended to animals, malnutrition, and poor hygiene. Older adults who self-neglect often have medical and social problems and have really high rates of depression and dementia in this population. It's important to keep in mind that in adult circumstances must substantially threaten their health for Adult Protective Services to accept the report. So if an older adult or a person with a disability is engaging in substance use, it's a legitimate concern, but the adult is still able to perform self-care tasks and their health is not substantially threatened, Adult Protective Services cannot accept that report. However, if the older adult engaging in the substance use and therefore is not seeking medical care, which is substantially threatening the older adult's health, then in fact, Adult Protective Services can accept that report. Anytime that we get a report for self-neglect, our goal is always to provide supportive services to help the older adult or adult with disability to care for themselves or to get access to the care that they need. Next slide, please. Now that we've gone through a couple of definitions, I'm going to pivot real quick to provide some context to the world of aging services. In 1965, Congress enacted the Older Americans Act. This law is the primary vehicle for services and funding in every state that support the dignity and welfare of individuals aged 60 years and older. These services include home and community-based services, nutritional programs, caregiver support programs, health promotion and disease prevention activities, and programs that protect vulnerable adults, such as the Long-Term Care Ombudsman Program. Next slide, please. So the Long-Term Care Ombudsman Program is authorized under the Older Americans Act, as I just said, but it's administered at the state level. It provides residents of long-term care facilities with access to effective advocacy in order to ensure that they receive the quality of care and the quality of life that they deserve and are entitled to by law. According to state statute, the Long-Term Care Ombudsman Program serves older adults and adults with disabilities who either reside in a long-term care facility or receive Medicaid waiver services at home and or are Medicaid, Medicare, dual eligible beneficiaries receiving managed care services. It's important to note that as of January 1st, 2019, the Adult Protective Services Program now has jurisdiction over abuse investigations if a person lives in a long-term care facility if the abuse occurred outside of the facility. For example, if an older adult is taken out of a long-term care facility by a relative, and therefore they're no longer under facility supervision, then that adult is abused by that relative while out of the facility, then a report to Adult Protective Services would be warranted. In addition, Adult Protective Services has jurisdiction to investigate a report if the alleged financial exploitation is perpetrated by a family member, a caregiver, or another person who has a continuing relationship with the adult. If the financial exploitation is taking place by a facility staff member or somebody within the facility, then it would go to the Long-Term Care Ombudsman Program. Next slide, please. A very quick overview of the components of the Long-Term Care Ombudsman Program include identifying, investigating, and resolving complaints made by or behalf of residents, providing regular presence in a long-term care facilities through frequent visits so that residents and family members can get to know the ombudsman and identify them as a resource, providing consultations or just information and assistance to residents, family members, and facility staff, conducting community education sessions to provide the community with information about various topics such as residents' rights, the Long-Term Care Ombudsman Program, or how to select a long-term care facility. Ombudsmen work on issue-specific advocacy through legislation and other means. For example, the state office works to advocate for the modifications of laws, regulations, or policies that affect residents in any way. Ombudsmen also work to support the development of resident and family councils by providing technical assistance. During routine visits, ombudsmen talk with residents and they see them face to face. This is when they most often get their complaints. They look around the physical building, they do a lot of listening, and they check for distinct smells. They look at the operations of the facility, like how does the staff communicate and treat residents? For example, are the staff really listening to what the resident is saying and what their real needs are? Are they taking their time working with the resident, or are they really rushing them just to get things done? Ombudsmen work to develop effective relationships with staff so that they have a foundation for working with the facility staff when problems arise. Next slide, please. I understand that Legal Aid Chicago provided a training on the Long-Term Care Ombudsman Program recently, so I was asked to keep this section short and sweet. So you all know now the different types of abuse that ombudsmen would investigate. You know what the Ombudsman Program is, and now you just need to know the action steps to take if you suspect abuse, neglect, or exploitation of a resident living in a long-term care facility. So if that is the case, please make the call to file a report. For any facility in suburban Cook County, with the exception of the city of Evanston, you can call Legal Aid Chicago and you have their number now. The city of Evanston Senior Services operates their own long-term care ombudsman program. Once a complaint is filed, the ombudsman assigned to that facility will follow up, advocate, investigate, and resolve accordingly. I've included a hyperlink at the bottom of the slide, which will take you to a PDF that has a full program contact list by county as a reference for anyone working outside of suburban Cook County. This also includes the members of the Office of State Ombudsman if you're interested in that contact information as well. Next slide, please. I'll spend the rest of my time with you discussing the Adult Protective Services Program. This program is a social service program provided by state and local governments serving older adults and adults with disabilities who need assistance because of abuse, neglect, self-neglect, or financial exploitation. In all states, Adult Protective Services is charged with receiving and responding to reports of adult maltreatment and working closely with clients on a wide variety of allied professionals to maximize client safety and independence. There is no federal mandate for this program, so Adult Protective Services programs vary from state to state. Per the Illinois Adult Protective Services Act, the purpose of the Adult Protective Services Program is to work with and on behalf of adults age 60 years and older and adults with disabilities age 18 to 59 to investigate reports of alleged abuse, neglect, exploitation, and self-neglect, and to intervene to prevent further maltreatment, and to allow older persons and the persons with a disability to live independent for as long as possible. Next slide, please. The Illinois Adult Protective Services Program operates under the following guiding principles to include self-determination, advocacy, collaboration, intervention, and health, welfare, and safety. I'll touch on the guiding principle of self-determination because it's a major component of the program and a principle that as legal professionals you might be interested in knowing more about. The Adult Protective Services works with adults, and when working with adults, there's a presumption that they have capacity unless we screen and determine otherwise. Therefore, competent adults have the right to decide where and how they live, whether they want to accept services, the right to make their own decisions, even if they're not decisions that you or I might make, and they have the right to develop personal relationships. It's the responsibility of the Adult Protective Services staff to remain open-minded and accepting of unique lifestyle choices, and it's critical that all persons working with any Adult Protective Services client recognize that the client has a right to privacy, so they don't need to tell you everything. This can be really challenging for our Adult Protective Services staff working with other service providers because it's really hard for other professionals to see an older adult or an adult with a disability not accept interventions that are offered to them that would really improve their quality of life or reduce their risk of abuse. But again, Adult Protective Services has to accept the client's right to self-determination and the right to make what maybe we consider bad choices, as long as they have the capacity to make that choice and understand the consequences of that choice. Next slide, please. For Adult Protective Services to take the report, several criteria have to be met. The alleged victim must be age 60 years or older or age 18 to 59 with a disability. The allegation has to meet the criteria for the definition of abuse, neglect, or exploitation or self-neglect. Now, keep in mind, you don't have to have proof that that abuse has occurred. You only have to have suspicion that abuse has occurred. The alleged abuse has to have occurred within the past 12 months, or if the abuse has occurred previous to the past 12 months, the effect of the abuse must continue to adversely affect the victim. The alleged victim must have ongoing relationship with the alleged abuser. We oftentimes get reports of scams, romance scams, internet scams. I just recently saw one of an art dealing scam. We cannot do anything over that because we have no jurisdiction when there's not an ongoing relationship with the abuser. Finally, the alleged abuse must take place in the home or community-based setting with the two caveats provided earlier in this presentation. Next slide, please. Once the report is made, the Adult Protective Services caseworkers have 30 days to make a substantiation decision. If there are extenuating circumstances, the caseworker may request a 15-day extension. During this 30-day assessment period, the caseworker will meet with the alleged victim, the alleged abuser, and others with information to gather data. The caseworker will refer to police reports, medical records, financial records, and other information sources to determine the validity of the allegations. Even before the completion of an investigation, the caseworker may start making referrals and setting up services. For example, if during the first visit with an alleged victim, the caseworker notices a lack of food in the home, the caseworker may make a referral for a benefits checkup to see if that individual qualifies for SNAP, or they might set up home delivered meals. Other services and interventions that might be provided throughout the process are getting emergency temporary housing set up, a house clean out for somebody who might be hoarding, guardianship if the alleged victim or the alleged abuser, the alleged victim lacks capacity to make decisions and they don't have a power of attorney, or if that power of attorney is the alleged abuser, assistance with petitioning for an emergency order of protection, referrals for in-home services such as the community care program, and referrals to services such as SNAP and LITIGATION, and assistance for paying for prescription drugs. Next slide, please. Although there are professionals in the state, there are professionals and state employees who are mandated reporters, anyone who suspects the adult is being mistreated by another should call the designated Adult Protective Services provider agency in their area. Or they can call the Illinois Department on Aging Adult Protective Services 24-hour hotline. If there's an immediate concern for an individual's safety, please call 911. Adult Protective Services are not first responders. While we do try to respond to severe cases within 24 hours, they're not going to get immediately seen like they would with 911. To locate the Adult Protective Services provider agency in your area for the area of the alleged victim, if they live in suburban Cook County, there is a link on the slide that you can click, and you can input their address and it'll pop up with the name and contact information for the Adult Protective Services provider agency. The second link on this side is to the Illinois Department on Aging's website, where you can find a list of all the Adult Protective Services agencies throughout the state. And to make a report at any point in time, you can always call the Illinois Department on Aging 24-hour Adult Protective Services hotline. The next couple of slides here are just for a reference that you can look at a later time. If you don't have the full address of somebody, this right here just has Adult Protective Services provider agencies broken down by township. So thank you for your time. And now Michelle is going to talk to you about Legal Aid Chicago's work.
Hello. Thank you, Katie. Zam, we want to acknowledge that not only do we work very closely with Age Options, we also receive funding from Age Options through the Older Americans Act to advise and represent people age 60 over. And we just really appreciate this great agency partnership that we have with Age Options. So the Consumer Practice Group at Legal Aid Chicago, in addition to doing financial exploitation cases, we traditionally represent clients in state and federal court, more like typical consumer litigation, and in bankruptcy court to save homes and preserve family assets. We know that seniors are disproportionately affected by scams and foreclosures and aggressive debt collection. Seniors are more frequently the victims of scams, not really necessarily because there's declining faculties, but often it's just because retired people are home when the phone rings or when the scam is knocking on the door. Seniors often also have built up equity in their homes, and so they're sitting on a large asset, and they may have substantial savings after a lifetime of working, and so they are vulnerable to predators. Or seniors who don't have savings are trying to live on a fixed income, may have home repairs, or are otherwise struggling to live on a fixed income. Next slide, please. So in addition to the traditional consumer protection cases that we handle, we do financial exploitation cases for our senior clients. Very often it is a family member or a longtime friend who has been the perpetrator of the abuse, and very often it's the adult children of the victim. And some of the largest losses, of course, involve people's homes, including fraudulent deed transfers and fraudulent mortgages. So I'm going to talk about a particular case that really illustrates the breadth and depth of the kind of litigation that we handle. Lottie Cade, we're using pseudonyms here. Lottie Cade was a frail 87-year-old widow. She had vision problems, and she lived in her West Side home since 1967. She shared with her daughter, and as she got older, the daughter handled everything. The daughter managed all of the household finances, had joint bank accounts, and just handled everything for the client. When the daughter passed away in November of 2010, this woman named Mary Greedy comes on the scene, and she claims to be a goddaughter. She obtained a power of attorney for Lottie. We're pretty sure that the client signed the power of attorney, probably didn't know quite what it was. But then she added herself to all of Lottie's bank accounts and credit card accounts and changed the address for all the billing statements and account statements to her home in the suburbs so that the mail wouldn't go to Lottie's house. After she drained the bank accounts and ran up the credit cards to the tune of about $100,000, she then arranged to have Lottie take out a reverse mortgage on the home, and she got another $51,000 from the reverse mortgage. The home had been paid in full before that point. Most of the money went to travel and gambling casinos and high-end, like fancy department stores purchases, high-end purchases. One day, Lottie's son Greg was visiting his mother, and he saw some utility shutoff notices on Lottie's kitchen table, and he was very surprised by this because his mom always had, she had enough money, she had savings, she had pension income and Social Security income. She was always able to pay her bills, so there was really no reason for the utilities to be unpaid. In fact, Greg had been contributing $600 a month and giving the money to Mary because he, Mary was known. He knew Mary was taking care of his mom's finances. They lived in a 2-flat, and he used to rent the apartment, or he used to live in the apartment on the 2nd floor. And when he moved out and bought his own house, he continued to pay $600 a month to his mom, so she wouldn't have to rent the 2nd floor apartment to a stranger because they were concerned that might create some danger. So that he was just sort of financially contributing. Next slide, please. So first I want to interrupt this case story to talk a little bit about the importance and the dangers of powers of attorney. Several of the cases that we're going to be talking about today involve agents who abused power of attorney, but we also want to emphasize that powers of attorney are an important tool for people to be able to plan ahead for incapacity and to be able to control and manage their lives by appointing an agent. And in fact, Legal Aid Chicago, we help people draft appropriate advance directives and powers of attorney. But it's very important that when considering a property power of attorney, that you must choose your agent with care. Has to be someone completely trustworthy because, as we're going to see, they are prone to abuse. So now we'll go back to Lottie's case. So this case actually involved 4 separate pieces of litigation that I'm going to talk about separately. First, there was a guardianship petition. Second, we did a citation to recover assets, and that was litigation against Mary Greedy to get the money back that she stole. There was a bankruptcy issue in the middle of all of that. And then the 4th piece of the case is a foreclosure case that was filed on the reverse mortgage. So first, I'm going to talk about the probate case. The son filed a guardianship petition, and he was appointed a legal guardian. When he discovered the theft, he immediately took over. They revoked the power of attorney, and he called the police, he called Adult Protective Services, an investigation began. He hired an attorney to file the guardianship petition, but the attorney really wasn't prepared to handle the complex litigation against the abuser, and also the son really couldn't afford the hourly rate that the private attorney he hired would have to charge to litigate that case. The court appointed a guardian ad litem to conduct an accounting of the missing money. And we received both the Adult Protective Services and the GAL, the guardian ad litem reports and all their investigation that detailed the fraud. So we could trace where most of the money went. That's how we know she spent most of it at casinos and things like that. Legal Aid Chicago got involved in the case, and we filed a citation to recover assets in order to go after the abuser. Mary hired a lawyer and fought back. She wasn't just she didn't default, she was fighting back. And in fact, she had the nerve to file a petition for fees for her services, her alleged services to our client. We engaged in, there was a lot of discovery and depositions, but despite several years of discovery, Mary produced virtually no documents and certainly had nothing to substantiate appropriate, to justify the money that she spent. Eventually, in 2019, we had a 3-day trial against the abuser. And on the third day of the trial, the judge persuaded the parties to settle. Mary was going down in flames, and the judge also persuaded us, it's better to have a settlement that puts some money, at least put some money in our client's pocket, because we could get $1 million judgment if we can't collect it. It doesn't really help our client. So at the end of the day, at the end of this day, because it wasn't really the end of the day, Mary agreed to a settlement of $50,000, and she's paying $1,000 a month, and she's still so far making the payments because that's going to take several years, of course. So the next piece of the case involved bankruptcy, and as I mentioned, Legal Aid Chicago has a very sophisticated bankruptcy practice, which I think really distinguishes us from a lot of other legal services agencies around the country that don't tend to have complex bankruptcy practice. Now, normally, of course, we represent debtors, and we're trying to save their homes or cars or preserve their income from garnishment, that sort of thing. But in this case, before the citation to recover assets went to trial, before the trial happened, Mary Greedy filed a bankruptcy because she wanted to wiggle out of the liability for the money she stole. Now, bankruptcy puts an immediate stay on any kind of litigation to collect money from the bankrupt debtor. So we had to, everything grinds to a halt in the probate court case, and we had to go to bankruptcy court. So we filed we represented Lottie as a creditor in this bankruptcy. We filed a claim, and we also objected to the dischargeability of this debt, because debts that are incurred as a result of fraudulent conduct are not supposed to be discharged in bankruptcy. We also, as we were investigating, we also discovered that Mary had a piece of real estate. She had a house in the south suburbs that I guess she was renting out to someone, I don't know, but she owned this house free and clear, and she did not list it in her bankruptcy filings. So we also brought that to the attention of the bankruptcy court. Ultimately, the bankruptcy was dismissed, and then we returned to the state court to continue on to the trial and ultimately to the settlement, but that put a delay. So another thing that happened while we were litigating this case is that a foreclosure was filed. By 2017, unfortunately, Ms. Cade had to go into a nursing home. And the way a reverse mortgage works is that no payments are due on the mortgage as long as the person lives in the home. But once somebody is out of the home for more than a year, or the borrower passes away, the reverse mortgage comes due. So a foreclosure was filed on the reverse mortgage that Mary Greedy had engineered for our client. So we filed an appearance in the foreclosure and asserted defenses, basically on the ground that she lacked capacity to enter into the mortgage, and also that she didn't receive any benefit from the loan because Mary stole the money. That case, partly because of the COVID moratorium and other kinds of delays and waiting, of course, case to be resolved. The foreclosure case has kind of dragged on a bit. The case is still going. We are currently waiting for the lender to take the deposition of Lottie's doctor, and we're pretty confident that the doctor will support our conclusion that she lacked the capacity to sign the mortgage and that she was vulnerable to undue influence at that time. It's a little difficult because the court determination of Lottie's disability and need for a guardian happened about a year after the mortgage was signed. So we're trying to prove something that in the past, but the doctor's notes are pretty clear. There are other red flags that, for example, Lottie signed this mortgage at Mary's house. And that it's very common for reverse mortgage borrowers to sign in their home, and the notary for the mortgage company comes to the house. But it's very unusual for somebody to sign a reverse mortgage at somebody else's house, and particularly someone as kind of frail and limited mobility that Lottie had. There's other red flags in the file that we also think that the lender should have noticed. Although, of course, the plaintiff in the foreclosure action is not the same corporation that originated the loan. But we contend that the loan was void from the start. And as a matter of equity, Lottie shouldn't have to pay back money that, you know, she'd never even received and didn't even know she was getting. The next slide, please. So this picture is not actually a picture of Lottie's house, but her home looks just like this, classic Chicago 2-flat. It's very well maintained. And Lottie and her family, as I mentioned, she lived there since 1967. Unfortunately, our client passed away at the age of 94, just about a year ago, a little over a year ago. And we're now representing the son, who is also a senior, in defending the foreclosure. Once the foreclosure is resolved, he's the sole heir to Lottie's estate. So at that point, he will need to file a probate to get title in his name as the heir. He has 3 daughters and a number of grandchildren. And this is a family home. He wasn't really a young child, but he lived there. I think he was maybe a teenager or so when his parents bought the house. You know, the family home represents virtually all of a family's wealth very often, and that can be passed down to the next generation, as well as being, of course, the repository of memories and the emotional wealth of a family. But when we preserve home ownership, you know, we're not just preserving the bricks and mortar and just a roof over their heads. We really are preserving the communities and the families and the communities where they live. Which leads me to the next presenter, Colleen Connolly, who's going to talk about family law and elder abuse issues. For CLE credit, in the chat, there's a link to apply for CLE credit, and this is the code. Please write down this number and use this code when you're claiming your CLE credit. And now I'll turn it over to Colleen.
Good afternoon, everybody. Thank you for joining us today. And I'd also like to say thank you to Katie, because Age Options, again, is a huge partner for us. Just a note on the terminology we're using. We often go back and forth between referring to our clients that we serve as seniors, older adults, elders, and a lot of that has to do with the terminology that's being used by the underlying act that we're relying upon, or the funding stream. For example, we get our funding from the Older Americans Act. So there's no precise definition, but again, we kind of move back and forth from that terminology depending upon where, what other resources or statutes underlie the work that we're doing. So we have a very robust family law program here at Legal Aid Chicago, and it does the traditional work in the sense of we do domestic relations work, we do child custody litigation, we do divorces, we do orders of protection, and we work also do some work in the probate division doing guardianship cases for minors and sometimes for adults as well. And the nice thing is that each of the statutes that we practice under most frequently does have tools that are uniquely adapted to the older adults for us to deal with situations where there is elder abuse, financial exploitation, or some other harm to a vulnerable adult. So that includes the Domestic Violence Act, the Illinois Marriage and Dissolution of Marriage Act, and the Illinois Probate Act. Next slide, please. So when we talk about doing domestic violence work or representing individuals with orders of protection, the image most people have is intimate partner violence. They think about a couple, married or not, in which there is basically the couple is, you know, comparable in age, usually in a romantic partnership. But the Illinois Domestic Violence Act is not limited to individuals in those situations. Many people are eligible for relief under the Illinois Domestic Violence Act because it recognizes other relationships in which domestic violence can occur, in which people are entitled to protection. And many family relationships are covered by the Illinois Domestic Violence Act, including parent-child. And that is where we see a fair bit of abuse of older adults, is a parent-child relationship. But we also see it between older couples. Just because you're old doesn't mean there can't be domestic violence. And we also see it in caregiving situations as well. So it's not necessarily a family member, but there's somebody who's coming into the home, either formally or informally, to provide some caregiving services. And so the Domestic Violence Act does specifically recognize that older adults are uniquely vulnerable to domestic violence based upon their age, maybe some physical limitations, and just the results of aging. Capacity to protect yourself becomes more limited over time. As a matter of fact, the Illinois Domestic Violence Act specifically says a adult with disabilities means an elder adult. It just means an adult prevented by advanced age from taking appropriate action to protect himself or herself from abuse by a family or a household member. Next slide, please. An example of a case that I worked on in which we were protecting a person was an elderly woman. She was monolingual, non-English speaker. She, in addition to being non-English speaking, she was not very numerate either. And so she was not able to independently handle her own finances, in the sense that she couldn't read a bank statement. She couldn't, balance a checkbook or anything like that. And at the point that I met her, she was living in subsidized housing, and she was receiving Social Security SSI income. So she had appointed her adult daughter to be her power of attorney. And that adult daughter was paying her rent, her subsidized rent, and was paying her utilities. And Wendy had about $500 left over every month after her basic bills were paid. And then Wendy's daughter had her sign checks made out to cash for $500 on a regular basis. And Wendy did that, signed the checks, because she was told that this money was needed to pay for things. And again, Wendy, didn't know how much things necessarily cost. And so she went ahead and she did this, but the money was never spent for Wendy's benefit. The power of attorney also added her name to the bank account. So the money was direct deposited into a bank account. Wendy never passed through Wendy's hands. And this continued for quite a period of time. And then her adult son, who did not have a good relationship with his sister, was visiting one time, and he found out, because there was no food in the home, or very limited food. And so he started to ask some questions about, why is there nothing, for mom to eat? He started to ask some questions, and it became very apparent that the sister was minimal food was coming into the home, although Wendy was also receiving food stamps. And so he tried to get an order of protection. He went to court and he filed for an order of protection, and he was not successful in getting an emergency order, although the petition was continued, and they came to us at that point, excuse me. And so we became involved in the case, and we looked into it, and what we were able to do is we were able to basically use the protections of the Illinois Domestic Violence Act, to get an order that the money that Wendy's Social Security money was to be immediately turned over to her son. It wasn't to be kept in the sister's hands. And we also, Wendy did have capacity to designate a new power of attorney, and she did that. And then we assisted in getting the changing the rep pay for Social Security, which actually took a little while, in part because COVID shut down, made it just harder to access the Social Security office. to make sure that got taken care of. And then also went back and worked with public benefits to make sure, again, the benefits were being directly administered to Wendy and her son. And as part of the litigation, although the emergency order of protection had been denied, we were actually able to persuade the attorney representing the adult daughter that it would be better if she didn't try and come around anymore, because she had the adult daughter had a history of coming around and being essentially just long, emotionally abusive conversations with her mother, in which she would consistently harangue her, ask her about money and ask her questions. And so we were able to basically get an agreement that she would stay away while the litigation was pending. Unfortunately, Wendy did pass away just a little while ago, and so the case is now over, but we were able to give her peace from harassment for the last year of her life. We were also able to make sure that money was available to her, and she actually got some, pleasant experiences in the last couple months of her life, to the extent she could, again, because of COVID shutdown, because there was money available just for the little pleasures of life that she had been denied because the money was being used for somebody else. So that was how we were able to use the Illinois Domestic Violence Act, again, to protect that individual. Now, classic case that we take is a divorce. Many of our cases are with families in which there are the couples are relatively young, they still have minor children in the home, but quite a few of our clients are not, they're older. And there are cases in which we see we sometimes see older adults that they're being taken advantage of or exploited as part of the divorce process. So the Illinois Marriage and Dissolution of Marriage Act, we can use the tools within it. We can get temporary and permanent remedies relatively quickly to protect assets, to ensure that there's a stream of income, and to give an adult some control over their interactions with their estranged spouse when we determine that the Illinois Domestic Violence Act isn't an appropriate remedy for us. So, for example, next slide, please. I have a client right now named Ronald, and this is a case in which an order of protection is not an appropriate remedy for various reasons, but it is a situation in which he's very vulnerable. In Ronald's case, he has been married for a couple decades, but it's actually a second marriage for both he and his wife. And they both have adult children from their prior marriages. And when Ronald and his wife got married, they did purchase a home together. And that's been their home for a couple decades now. And Ronald has a chronic degenerative disease. His health is declining over time. He still has cognitive capacity. He understands what's going on, but his ability to care for himself is becoming more limited over time. And so he essentially needs round the clock care in a home. He needs somebody to be there at all times to help provide care. And honestly, just to keep an eye on him, because he's very vulnerable. And it also adversely impacts his ability to communicate. He can communicate, but again, it has to be somebody who's familiar with them and basically can sort of like interpret the shorthand that Ronald uses when he's trying to express his wishes or anything like that. So Ronald, a few years ago, did appoint his oldest daughter, or excuse me, one of his daughters, as his power of attorney for both healthcare and property. He and his wife were still living together at that time. But then his wife had Ronald sign two documents. One was an agreement to list the marital home for sale, and the other was an agreement to purchase a brand new piece of property. And then she left the house after having him sign these things and filed for divorce. And her attorney almost immediately filed a motion to force, to say we want to list the house for sale. And at that point, his power of attorney contacted us seeking assistance for Ronald, and we agreed to take that case. Now, the power of attorney was very protective, and she took immediate steps to rescind the contract for sale. She pointed out that she was the power of attorney and that he shouldn't, that it was signed without it being explained to him what it was. Luckily, the seller, it's a subdivision, basically immediately canceled the sale. So there wasn't any issue about that. So that issue was very quickly resolved. But what we did was we were representing Ronald in the divorce. And one of the first things that we did was we immediately filed a motion objecting to the sale of the house. Because we said, this man, he is, and he's living in his home. If this home is sold, where is he going to live? And the other thing was that the spouse also filed a petition for maintenance. There is a discrepancy in income between the two of them. Ronald does have a stream of income that is significantly more because he has pensions and Social Security, and she has much less. But basically, all of his money is needed to provide for his daily needs. There's not, it's not as simple as discrepancy in income. The wife is entitled to maintenance. And once we filed filed motions objecting to the relief that they were seeking on a temporary basis, the opposing counsel basically opted not to proceed with their motions. So we were in the position where we were able to keep the sale of the house from moving forward. We're now in the discovery phase. And the issue that's come up fairly recently is that the wife has shown up with her adult children, and basically that has caused Ronald extreme distress, because although at first he said that he did want to see his wife because that's, emotionally he wasn't ready for a divorce yet, the fact that she's coming over and these people are just, honestly badgering, him and his healthcare provider, and also coming in and rooting through stuff and saying, "Oh, this is ours. We're going to take it with us." It's just a level of stress that he doesn't need, and Ronald's ability to advocate for himself in the moment again is very limited. So we are in the process of negotiating a more complete stay away order so that there's not the same pattern of harassment. Unfortunately, in terms of moving the litigation forward, the opposing counsel has recently withdrawn, so we're kind of on hold while we wait and see whether or not they hire a new attorney or what happens next. But our goal is to have this case wrapped up in such a way that he's able to stay in that home for as long as possible, and to make sure that there's not any sort of dissipation of any assets, although the house is the most significant asset, that would adversely impact him if at a future date he does need to go into a nursing home. Because of course, if you need assistance, you need to get Medicare to pay for a nursing home. There's various rules about not giving away all of your assets, giving away all your wealth in order to be eligible for the state to pay for your nursing home. So again, we want to make sure that whatever happens, it's done in such a way that it protects him in the future if he needs that. So right now, again, he's in his home and we're litigating this case, and Ronald is feeling a lot easier because he knows that he's got an advocate for him. And we have talked about what a plan looks like in terms of trying to get this case, resolved. And he has signed off on that. So he feels a lot more comfortable because he knows he's ill. I mean, he does know this. Again, he has capacity, but he's now able to basically know that there's a plan to protect him both in the short and long-term future while we work through that. Next slide, please. And then finally, I want to talk about the Illinois Probate Act, which again is the mechanism by which you can seek a guardianship for an adult or for a minor. Now, the statute is designed with a fair number of protections for adults to prevent an inappropriate guardianship order being entered. The statute does value maximum capacity, respecting capacity, and not appointing a guardian for somebody who doesn't actually need one. So there are protections built in, but the reality is that if somebody agrees to a guardianship, it's quite easy to have a guardianship order entered. If there's a medical report and a consent, it's fairly straightforward. And what happens if the guardianship statute is abused is then you have an individual who is now legally disabled adult, and there's very little they can do in order to live independently on their own. Next slide, please. So we actually encountered that situation. There was a woman. She was not from the United States. She came from a country in which an arranged marriage, traditional marriage was the norm. She had an arranged marriage. It was a traditional marriage. She basically stayed in the home and raised her children, did not have a work history. She was and not literate. She's not very fluent. She spoke a little bit of English, but not very much. And a report was issued which basically said that she, was low functioning. She didn't have a lot of capacity, and they relied upon a lot of things, including the fact that she wasn't very numerate, as proof that she wasn't able to handle financial affairs. And her husband asked her to sign a document agreeing to appointment of a guardian, and then the client did it. Her husband told her to do it. She signed it. The guardianship order was entered, and then her husband essentially kicked her out and basically refused to support her. He had other reasons why he wanted to do this. He wanted to get a divorce, and it was a very complicated situation. But the ironic thing about this, that's not the right word. What the unusual thing about this was, Nadia came back to the marital home every day to do the chores, make the meals. I mean, she continued to do all the housework that she'd done traditionally, but her husband just kind of left her hanging out there to dry, refused to support her. So she eventually got connected to a social service agency that specialized in working with the ethnic group that she is a part of, and they got her into some housing, and then they connected her with us, and we actually represented her in the guardianship case where we filed a petition, or she asked to have the guardianship discharged, and we represented her in that. We did a lot of work because we had to find somebody that was willing to do an evaluation, a current evaluation, that say that she was competent. Eventually that happened, and so Nadia was discharged, and now she again is a no longer disabled adult. And thank you for your time. I'm now going to turn it over to Melissa Paciullo, who will talk about our pro bono opportunities.
Thank you so much, Colleen. And hearing from you and Michelle about these cases again reinforces Legal Aid Chicago's unique position as an expert in so many areas to be able to effectively meet the needs of a population like seniors. And I'm so inspired by the work that you are doing, and I bet there are many people on this webinar who are too. So lucky me, I get to talk about opportunities to get involved by volunteering with us. We have a variety of opportunities available, offering everything from a commitment of a couple hours at a help desk to a longer term representation, and all of our opportunities involve direct client services. One opportunity that can help this particular population is what Michelle referred to, which is called our ADAPT program, Advanced Directives and Property Transfers. As Michelle mentioned, attorneys can help by preparing powers of attorney for healthcare and property, and transfer on death instruments. And a transfer on death instruments allows the transfer of ownership of a home without the necessity of a will or probate process. And you heard both Colleen and Michelle talk about the importance of preserving a home, and particularly Michelle talking about the importance of being able to pass down a home among generations. And so this relatively simple document can preserve that for generations to come. This opportunity is purely transactional and fully remote at this time. There is, of course, training available that is available online and on demand, and eligible for even more of that valuable CLE credit. if you're interested in helping out this population with a low entry level time commitment, we welcome you. And you can find more information about all of our volunteer opportunities on our website. And you're of course welcome to reach out to me with any questions that you have about any of our opportunities and how you might be able to help. And I'll turn it right back over to Kate Schenk now.
Thank you, Melissa. Thanks to you also, Catherine, Colleen, and Michelle for those very engaging and informative presentations. This concludes the planned content portion of today's presentation, but in a moment, we'll start the question and answer part. Before we do, a quick reminder, we would appreciate it if you could fill out a brief survey about the presentation. So to do that, or if you'd like CLE credit, please click on the link that's in the chat and fill out the form. And please note that the certificates of attendance will be sent out within the next week of attending. We also really invite you to join us next week for our session discussing the needs of people with disabilities. So this will be next Wednesday at noon Central. So the panelists are going to remain on to answer your questions, which you should type into the Q&A at the bottom of your screen. And I know that we have some questions that have already come in and ask if Melissa, could you please take us through those Q&As?
Wonderful. Thanks, Kate. So we've got some great questions here. And again, if you've got some, go ahead and put them in that Q&A. A couple questions on the Adult Protective Services side for you, Katie. So the first question that we got is, are Adult Protective Services reports made anonymously?
Thank you. That's actually a really great question. So the reporter's identity will never be shared with anybody throughout the process. However, we do ask for the reporter's name and phone number because we have an intake person that will ask all of those important intake questions, get the information about the alleged abuser, the alleged victim, get that contact information, and then that intake goes to a caseworker. And when the caseworker reviews that intake, sometimes they have follow-up questions that they like to ask. So we do like to get that person's name and contact information if they're willing to. However, during that intake, the reporter is allowed, or we welcome the reporter to say, no, I'm sorry, I do not want to be followed up with at this time. I'd like to remain anonymous. We take it both ways, but even if the reporter provides their name and contact information, that information will never be shared with anybody other than the caseworker.
Wonderful. And Michelle, you mentioned our bad actor, Mary Greedy, which I assume is a pseudonym, but what a clever one. And the question has come in sort of, isn't some of Mary Greedy's activities, wouldn't they rise to a criminal level? And was she ever referred for prosecution or charged with a crime?
She was, excuse me, she was never charged with a crime. There was some police involvement early on when the son just, kind of frantically trying to, was looking for help to figure out what happened to his mom's money. But the unfortunate reality is the vast majority of these crimes are not prosecuted by the police or criminal authorities. And, sometimes it's just seen more as a civil problem. I think the larger issue is that for a criminal prosecution and proof beyond a reasonable doubt is very difficult when you have a victim who can't tell you what happened. And when you have somebody on the other side who said it was a gift, I gave my life to this older person, she was like a mother to me, and so I was just being rewarded, for all the good things I did for that person. So it's a sad reality that is very rarely criminally prosecuted.
And I'd like to jump in and mention that sometimes, not in the case that Michelle was talking about, but in many cases we encounter, the older adult is reluctant to pursue it as a criminal matter because of the implications for what is often a family member. Maybe somebody that's a fractured relationship, but it is somebody that they feel a certain sense of responsibility for, particularly for adult children. So that's another reason why these cases sometimes don't get prosecuted. I'd like to say that Adult Protective Services, one of the nice things that they do is they try and have regional, what they call M-team meetings, multidisciplinary meetings, in which the Adult Protective Services have the opportunity to sit down with people in other areas that have high encountered with seniors and seniors that are being exploited, and talk through problems and do problem solving. And both Michelle and I are on M teams, and the Skokie, I belong to one in Skokie, and they're very lucky because they have the Skokie police detective come to most meetings, not all. And it's really nice because you get to hear the perspective of them being very frustrated sometimes about why, they're working on cases. And it doesn't move forward criminally. The cases that are presented to M team are confidential. They don't give any information. But the number of times a police detective would be like, "Oh, yes, I think I know what case you're talking about," and so there are many ways in which, other than just directly reporting the crime to the police, there are other ways in which Adult Protective Services does try to work with law enforcement.
Thank you. And so another question for Katie, which is about the relationship requirement that you mentioned for reporting something to Adult Protective Services. Would a landlord-tenant relationship qualify?
Yes, so that certainly would qualify because there is an ongoing relationship between the landlord and the tenant as that person continues to reside in that facility.
Great, and we've got a very astute attendee who is asking us to make sure that we remind everyone that there are multiple regulatory systems available, including that if someone is suspected of being abused in a nursing home, another option for complaint is the Illinois Department of Public Health, which runs a central complaint hotline. And we can put that number in the chat. It's 800-252-4343. You can make a complaint to the Illinois Department of Public Health. We'll investigate whether or not the facility has violated federal requirements through Medicaid and Medicare. And of course, IDPH will follow up on those complaints, as well as has the ability to issue financial penalties and other types of denial of payments. So just another resource if for those who are residing in long-term care facilities, that the Illinois Department of Public Health is actually the agency charged with investigating those complaints. And that what we're really seeing here is an overlay of services designed to protect those who are living in long-term care facilities. We've got a couple of questions here from the audience, in particular for Michelle and Colleen, about how we, when we provide services to seniors, and particularly in the ADAPT program, what we do to make sure that we're not dealing with somebody who's potentially abusive or intends to do wrong to the senior. So either one of you want to talk a little bit about how we ensure that our clients are kept safe?
Well, it's a really good question, and I mean, to some extent, our ability to do that is somewhat limited, except to very carefully advise the client. Now, one thing when we're advising and representing clients in the ADAPT project, or when any attorney is doing those kinds of advanced directives, it's very important that you speak with the client completely separate and apart from any other person, even if there's no suspicion that the adult child or whoever is going to be named the agent, even if there's no suspicion that their person would ever do anything wrong. But it's still very important to both to assess the client's capacity to understand what they're doing, and they have the capacity to sign these documents, but also just to give an opportunity to make sure that they're not being influenced by the other person.
The other thing we do is that we make sure that the client understands all of the delegated authority that they're giving them, because there are some clients who, when it is explained to them that they can put some limits on the power of attorney, will do that. And the second piece is that we always also make it really clear how a power of attorney can be canceled or voided or rescinded, so that if something happens in the future where the person is no longer comfortable with that agent, they know exactly what they need to do in order to rescind the power of attorney. And then we also talk about the importance of making sure that the agent continues to be able to carry out their function, because we sometimes see adults appoint other people who it's not unusual for a husband and wife to do a power of attorney. And so you do need to be really, understand, okay, husband, turns out that your wife, who just appointed your agent, you have reason to believe that she can no longer carry this out. What do you do? So you counsel them also about if reasonably foreseeable that there might be an issue about capacity for their agent. I mean, it's just a realistic thing to do.
Yeah, that's great, Colleen and Michelle. And I think one thing I would add, Michelle, you mentioned assessing capacity. In our first session in this webinar series, we heard from Janelle Pedroza, who is one of our social workers on staff and the head of our client support services. And if there's a question as to whether a senior has capacity to execute a power of attorney document, we'll actually have we'll have Janelle come in and do an assessment so that we can feel more comfortable proceeding. And so that is something that we will use our multidisciplinary resources internally to be able to do.
And we have told people that we're sorry, but we're not going to do it. We're not going to do this for you. And in most cases, the client, the signatory, I don't think we've ever had like a really strong pushback, although a couple of family members who've come in proposed agents have been very upset with us for saying to do that. And it's sort of like, well, and the number of people who call and actually like, my mom's incompetent, I want a power of attorney. It's like, that's not the way it works.
Yeah.
So we do also have to educate family as to the limitations of a power of attorney, because a lot of times it's not that they're going to abuse it. It's just, it's too late to use this as an instrument. And so we have to counsel them as to what their other options are.
Thank you. And Michelle, there's a question here about attorney's fees in any of these cases. And so in any of the situations where you're helping someone recover from a bad actor through fraud or other means, are there opportunities for us to get rich and get attorney's fees?
Well, sometimes it's funny. My background is in consumer litigation. And so I've had attorney fee cases my whole career, mostly suing banks and mortgage brokers and home repair contractors and that sort of thing. In the financial exploitation cases, there are some opportunities for attorney fees, and particularly, well, if there's a criminal prosecution. But the reality is that most of the time in these cases, the money is gone. And, we're lucky if we can get anything back. If we can get house title back, then that obviously represents a substantial value. But most of the time, these people, sometimes I call them the impatient heirs. They've already spent, the money's all gone. It's either gone to gambling or drugs or other, expensive things that are, there's no money left. So as a legal aid agency, we are able to litigate those cases even when we can't really go after if there's no money to collect, but sometimes when there's a limited amount of funding to collect, we don't need the attorney fees, and we can get the money, some of the money, like in this case, maybe a third of the money is going to go back to Ms. Cade.
Thank you so much. And so there's a question here about, I think, a potential back pattern, which is that, is it possible to assist a senior that signed paperwork about their home but wasn't really educated about what they're signing? So Michelle, would you mind talking about both what you think could be potential remedies there, as well as how to connect with us if you have a client who might be interested in our services?
Yeah, I mean, I would say the vast majority of my cases in the last 20 years involved somebody who signed something they shouldn't have signed. Either they didn't understand, it was flat out misrepresented, it maybe, altered documents. But even, sometimes, highly educated people can get caught up in a situation. So, the short answer to the question is that very often something can be done. But every case is so specific. And there's so many facts that go into a determination of whether you can support a fraud case, including things like the person's ability, vision, language, education, physical, other physical disabilities, and the relationship with the defrauder. So there's so many factors that go into the decision about, what we can do and how much we can do.
Great. And Colleen, can you talked a little bit about divorce often for older adults. Can you talk a little bit about how a court would determine whether or not spousal support, also known as maintenance, might be appropriate in a particular case?
Well, one of the relatively nice things about doing divorce work is that the calculation for support is pretty straightforward. Obviously, with like super wealthy people, there tends to be a lot of variation from the statutory guidelines because the resources are available to do it. But for our clients with a very limited stream of income, limited assets, it's more a matter of figuring out exactly what the stream of income is and what the relative expenses are, and then talk about, and then you can eyeball a case relatively quickly and tell somebody what the what it's likely to be a spousal obligation, the maintenance. Maintenance is not highly favored. I mean, it's an existing remedy, but the attitude that sort of like underlay it a couple decades ago is no longer prevalent. And so there is kind of an assumption that you really have to, it's pretty cut and dried because judges and attorneys just basically don't want to spend hours litigating how much money is going to be transferred between parties in the divorce. So again, it's a very fact specific, but again, for our clients, it's usually pretty straightforward in terms of eyeballing what a likely obligation is going to be, both,
Right.
Give or receive.
Right. And of course, with this population, there are many seniors and older adults who have difficulty traveling. And so do we ever take the show on the road? Do we arrange to meet clients closer to their home? And I think actually right before this webinar, Colleen, you were talking about a visit you just made.
Yeah, as a matter of fact, I went to a nursing home to help a nursing home resident get a divorce, because before we had been thinking, oh my gosh, how are we actually going to, make this happen? And then COVID happened, big shutdown, and his divorce was delayed for a period of time. But eventually we got it done. And so moving forward in situations like that, I think the courts are going to be far more receptive to the idea of saying, let's go ahead and do a video hearing because of this individual's vulnerabilities. And it was nice because the judge in the case, Judge Kubalanza, actually, as soon as she realized where I was, she immediately put us into a breakout room and said, I'm going to give you guys some privacy and some dignity to do this. So it was a relatively positive experience, both for how quickly it happened and also for how the judge treated my client.
Nice.
Although I looked ridiculous because I had to wear all this protective gear.
Not your ideal court appearance attire, but you made it work, right? Which is great.
Right.
And I can say that personally, I have traveled to meet individuals to be able to execute powers of attorney. I happen to be a notary, so I will bring my notary stamp with me and meet people where they are to be able to execute those. We can't do it for every client just because our resources don't allow us to do that, but we have definitely done it to be able to meet people and make sure that they get these really important documents. And I think that's one of the philosophies that we all have. I should also say that we sometimes too often make assumptions about whether someone has the technology capability to do something with us. And so during this pandemic, we've actually been executing remote notarizations, which have worked really well with as long as people have the ability to ask someone else to help them with it. And those very helpful family members, those very helpful friends have been able to assist us in getting these documents executed, and we're able to do that remotely. So I just wanted to say that, we do try our best and that we should never make assumptions about what someone can do to engage with us.
Yeah,
I
wanted to jump in because I want to say that in 20 years, I have very effectively represented hundreds and hundreds of, full-on litigation cases, doing everything by, between phone and fax and email. And this was in the days before we had remote hearings. Of course, I will go to a client's house if they can't travel and I need them to sign something or for other matters. But it is possible to do this work. And I even had more than one client who I represented at length, and then, but never met them. And then they saw my picture in the newspaper, and then they called me and said, I didn't know that's what you looked like.
I'd like to point out too that in addition to seeing clients in their homes, sometimes clients don't want us to come to their homes for all sorts of reasons. And because we have a close connection with Age Options, and we're often able to use that network to assist the client finding a place to meet in a local senior agency, or connect them to a local senior agency for support. And we often have a connection to somebody at the senior agency that can help facilitate some of those transactions in terms of like getting a fax to us, or helping the client get a document notarized. So there are many ways that we work around the client's circumstances. If they can't come to us, and for whatever reason we can't get to them, there's other ways that we facilitate that relationship.
Wonderful. And so sort of zeroing in on one of our last questions, there's a question here about other transactional opportunities for pro bono work other than the DAP program. And I'm just so thrilled to be able to get a question like this. We do have other transactional type opportunities, including we talked last week about our criminal records relief program, which involves preparing expungement petitions for both juvenile records and adult records. And those are both transactional opportunities. It's a preparation of a paperwork and then you're done. So I encourage you to check out our website to see what other types of opportunities might be appropriate, but that's another example of a transactional type of opportunity. And then we'll just take this last one real quick. And then the question is, are the services provided by Legal Aid Chicago state, county, or citywide? That should be an easy one for one of you.
Well, we are Cook County, so we represent clients in Cook County, but the reality is that many people have cases in Cook County and they don't live in Cook County. So we represent people who don't live in Cook County because they have a domestic relations case here.
Great. We'll turn it back over to Kate.
Thank you, Melissa. Thank you so much to our presenters. We're grateful to Sidley and the rest of our sponsors. So appreciative for our wonderful relationship with Age Options. And thank you so much, Catherine, for joining us today. And thank you to you for spending this hour plus with us. We hope that you will join us next Wednesday for our 4th session at noon on Wednesday. Thanks again and enjoy the rest of your day.